That needs to be done to, I don't know why you're giving me the attitude.
No, I'm not trying to. I'm sorry.
Yes, you are. Either that or it's because you're high. I don't know which one it is, but you're giving me attitude, and that attitude will most likely be readjusted by me at the Bexar County Jail. So I don't know if your attorney told you this, but I can send you to the Bexar County Jail as a condition of this probation, and I can also send you to the state jail facility as a condition of this probation for attitude readjustment. Do you want that?
No.
Did you move in then, or what did you do?
I have issues when I go to his house. I can't go there. I have autoimmune issues.
And I have also,
I wasn't talking to you.
okay, that's nice.
You know what, young man? I'm going to tell you one thing right now, and I'm going to tell you, you better check yourself. So I'm going to give you a minute to go out into the hallway. Otherwise, what's going to end up happening is you're going to be in contempt. I was talking to Ms. Cunningham. I wasn't addressing you. I don't know why you felt a necessity to interrupt her as she's addressing the court. So you might as well take yourself out of this courtroom right now. Right now. And when you feel like you can behave yourself, then you can come back in.
And
I can't tell because it's not entered in the computer system. It's a felony case, and for whatever reason, the court has decided that we don't enter felony cases until the day of the hearing, I guess. I don't.
Counsel, your sarcasm is not acceptable. And that is not, and that, please don't interrupt me. And that is not what the court has decided to do.
At any time, intentionally, negligently.
Not intentionally. I was backing up.
I don't care. Stop. Listen
Sorry.
to my question. Did you at any time, either intentionally, negligently, recklessly, in any way, shape, or form, damage their truck?
No.
So at no time, through any actions of yours, at no time did you damage their truck? It's easy, yes or no?
Can I explain?
No. Yes or no?
No.
So you've never at any time did any type of conduct in any way, shape, or form that would have done any damage, a scrape, a nick, any type of damage to their truck? Yes or no?
See, sorry, it's hard for me to answer.
It is not. It's a yes or no.
Well, I'm not trying to lie, but
It sounds like you are.
no, because their son backed up. I was backing up and he cut me off. And so that's when I bumped it. So that's why
Don't care about
I'm
explanation.
so then I guess, yes, I guess I'm not really sure because it wasn't intentional and that wasn't ever my main fault,
Miss Mott,
you know.
zip it.
And then they live with their dad.
Okay, she's
Joint custody.
talking about, you're being very dishonest and slippery with me because I asked you, my mind is a steel trap, but I wanted the court reporter to read back because maybe my mind is failing, but I highly doubt that. You told me that your children were living with you and their father, and you said the other father, he's not a part of anything. Now you're telling me, oh no, he doesn't live with me. It's on and off. You've been dishonest with me from the very beginning. You were dishonest when I asked you if you're going to be positive. You were dishonest about that. Then you were dishonest about Bloodworth. I don't even know if this is this person's real name or not. Then you were dishonest about Sarabia. At first, and later you said he was the father of your children. Now he's not the father of your children. You're just being dishonest all across the board with the court, and I don't appreciate it.
Have to feel about it. But Ms. Bacon, your conduct in this case has been abhorrent. You have absconded over and over again.
Buckle up, guys. Today, we are going to witness a courtroom spiral where authority, attitude, and accountability collide fast. The judge immediately calls out perceived disrespect, warning the defendant that behavior alone could land them in jail. Interruptions, sarcasm, and defiance escalate tension, culminating in a direct removal threat. What should have been a controlled exchange quickly becomes a power struggle, with the court asserting dominance to restore order.
And you've never complied with bond. You make excuses for it. Your response to the assessor, the way you responded to them as recently as 10 days ago, you say you got cleaner in the jail, but you were already in jail for a month when you saw her and you still acted the way you acted.
together and he can still have his complaint, I guess, that he has. And maybe if he'd listen to his attorneys, he won't have the complaint. But I'll let him do what he's going to do. I'll adjourn it to June 22nd, 2023, 9 a.m. Motion. All right. See? Okay, why don't we do this? If he wants to play it that way, we'll just make both those hearings in person. Because if he wants to play that way, Mr. Brown, what do you want me to do with that?
Your Honor, I will leave this completely in the court's discretion. Absolutely.
Okay, let's bring him up. I'll set that in person. That's at 2 p.m. on the 22nd, and we'll see how he wants to act that day. His request for withdrawal of counsel denied.
Prior to this one, I tried to work with them, but could you please stop? This is why I really just don't feel like I should work with them.
Just a minute. Mr. DeMayo?
Yes, Your Honor.
Sit down and pay attention. You're in a court proceeding. Don't get up and walk away because you didn't like something somebody said. You're asking for her grace to let you stay until the end of May, and then you act like that.
I'm sorry.
Otherwise, we can have a hearing and you can be out in 10 days and the sheriff will put your stuff out in the street. They allege your kids are dancing on the roof. They're breaking windows out. There are other allegations that have led them to terminate the tenancy. You haven't paid the rent since September and you're full of indignant disgust.
McKnight.
Oh, you know I'm pregnant. I can't do all it.
Miss McKnight, you got to stop getting pregnant, ma'am. I know that's not a thing that people supposed to say, but you keep bringing kids into this world and you can't take care of them. Please stop.
Well,
it's like every year I see you, you got 2 kids. Miss McKnight, this is not fair to these babies. You keep having, what are we on, number 8 now?
No.
7?
Yeah.
Miss McKnight, you know you can have sex without having a baby, right?
He sits right now.
Okay.
Don't interrupt me. We're going to have a way to, you know what? Tell you something, Mr. Montgomery. I know you'll hear me. I'm going to tell you right now, I expect people to conduct themselves in certain ways in my courtroom. I don't know. Just listen to me. I don't want this other stuff in terms of comments that I'm making. I will show you respect, but the one thing I will not let happen, ever, you can sit up there and you can disrespect me all you want, but I will never let this institution in this courtroom be disrespected. So I'd suggest that you watch after I say something, what comes out of your mouth, because whether or not you're intending to give that impression, you certainly are to this court giving that impression. And if you continue to do that, and you've done it 2 or 3 times today, and I let it slide, but if you continue to do that, you're going to feel the full wrath of this robe come down on you, and I don't want to do that. Am I understood?
Yes, Your Honor.
Thank you.
Supposed to spend the night with him and I was supposed to pick them up that morning.
No,
That's why I was there.
so you're saying there was not a CPS safety plan in place?
Yes, there is. Mhm.
All right.
And the plan that me and Jacob had came up with was for his dad to be on the plan and my mom to be on the plan.
Just these ones, like, I just want to guide you.
No. I want to listen to what she's saying because she's changing her story to me.
What, may I have a minute?
No,
Thank you.
she's on the witness stand. So go for it.
From a third-party view, the courtroom shifts into a series of confrontations, revealing patterns of non-compliance. The judge methodically points out inconsistencies, dishonesty, and repeated failures to follow bond conditions. Attempts to justify behavior are cut off, as the court demands direct answers and accountability. Even when personal hardships are raised, they fail to outweigh the judge's focus on conduct, creating a tense atmosphere where excuses no longer hold weight.
I'm very remorseful for what happened that day.
No. Let's go back to the safety plan business.
Yes.
So you're saying there was an agreement with the safety plan for what?
Just for my mom and his dad to be on the safety plan. That's it. That's all I was gonna say.
No, your mom just testified. You heard her testify that says she was not considered for the safety plan. So she was not on a safety plan.
Coming anytime soon.
How does it not sound like payments coming anytime soon when I just gave you guys $1,600? Before I gave you guys $1,600, I gave you guys $250. And before I gave you guys $250, I gave you guys $175. And this was and you guys just took over. This is my first time ever being late on my rent. I can't help that I got sick and I had major surgery. I was in the hospital for over a month. I can't help that. I apologize.
Mr. Yates, Hickenbottom, let me just tell you something. You're not going to come into this courtroom and try to yell at anybody.
I'm not yelling at
It's
anyone.
not, no, it's not going to happen. It's not going to, you want to try to overtalk me? Really? Do you want to do that today? I'll wait for your answer.
No, Your Honor, that wasn't my attempt.
Response from JSG, and I'm going to tell you, lying to me is a problem. This is the response about the tether. And don't tell me your DOC agent took your tether off, because what I'm about to read to you, your DOC agent did not do. Good afternoon. It was retrieved by one of our agents who located the device out in the field on November 30th. I believe near the location of removal. I did have a cut strap and the charger was not located. So tell me again how your DOC agent cut your tether off of you and threw it in the field.
When I got out Google, October 13th.
The tether was removed on or about November 28th, the day you missed court. Mr. Ray, tell me another story.
I cut the tether off.
Yeah, you cut the tether off.
You've had 3 motions to revoke in this court. So, and I know that each time you came before me, I've told you that you're looking at up to 10 years in the prison. Deputy Laura, could you do me a favor? Could you place the handcuffs on him?
As proceedings continue, the situation intensifies with direct accusations of lying and manipulation. The judge presents evidence contradicting prior statements, exposing inconsistencies that damage credibility. Warnings turn into consequences, with handcuffs ordered and the possibility of prison emphasized. Observing this moment, it becomes clear the courtroom has shifted from evaluation to enforcement, where patience runs thin and authority is exercised decisively.
Please. Each time you come before me, I know I've told you you're looking at doing 10 years in prison. Obviously, your mother is not laying down the law with you at home.
I got in the file the date of the hearing.
Well, that's why we need a hearing then, because there was 2 orders.
Sir, you're entitled to have a hearing, but I'm gonna tell you one thing. If you have a hearing, you better check that attitude outside. 'Cause I don't accept that.
I don't have an attitude. Can you not hear me? I'm speaking up so you can hear me. I'm talking on the phone.
You got one. I don't accept that because I don't talk to you like that.
So, ma'am, I'm just going to give you a fair warning. If you think I'm not, you didn't think I was serious about my last order. If you think I'm not serious about this order, you're going to find yourself very wrong. Because if you're not in that jail by 6 p.m. this evening, I will send somebody to get you.
I understand, Your Honor. I'm sorry that you feel that way, and I hope we can resolve this.
You better be quiet, because she's about to pick up a whole lot more, Miss Anderson.
And it may be moot anyway if the treatment program does not allow him to go. At this point, I'm going to put this on for September the 12th, 2023 at 10 a.m. And you must submit the documentation.
Vincent, I'm going to come see you today. Let the judge finish talking. Sorry, Your Honor.
Mr. Vincent Klein, if you continue to act up, I'm going to not consider this at all. Well, he seems to not want to stop giving me that behavior, so I can just say, forget it and not consider it at all. Stop it now. I'm tired of it.
Do you have any children?
Yes, ma'am.
What are their ages?
4, 3, 2, 1, 6 months.
And where are they? Who are they with?
Their mothers.
How many mothers?
3.
All right, that is not Black excellence. The fact that you're here is not Black excellence, unless that's the name of a building, but I'm assuming it's not. So you are not showing Black excellence to your ancestors or to your mother, your grandmother, or anyone. You understand?
He's availed himself to the court every time that I've had anything to do with him.
Why didn't he turn himself in between the time I revoked his bond and today? Just gonna come out to court. Because you, as an officer of the court, should have instructed your client to do that the court had revoked his bond. So I want an answer.
In the final stretch, the courtroom becomes a stage for broader accountability, extending beyond the case into personal responsibility. The judge confronts repeated behavior patterns, including failure to support children and ongoing disregard for obligations. Frustration peaks as the court highlights long-term consequences and unmet duties. The tone is firm and uncompromising, closing the session with a clear message about responsibility and consequences. Like the video, subscribe to the channel, and we'll see you in the next video.
That question.
I mean, we were going to be here today.
That's not an answer to my question. Mr. Allen.
According to what the defendant just told his attorney is that he told him to just show up today and not turn himself in.
That's correct, Your Honor. I mean, and that if...
Oh, give me your handcuffs, man. That's a wrong answer.
I'm sorry. I mean,
way the wrong answer.
I'm sorry, man.
I'll deal with this in a minute, because right now I'm furious, Mr. Vincent, that you would represent that client. Defendant remanded. Take you. Court's going to stand in recess.
Okay. So let me explain something to you. Children cannot support themselves. And it appears to the court that you're just having children and allowing somebody else to support them. For example, if I were to have a child, I can't say, oh, cute baby, and then put them at Travis Park and say, good luck to you. And that's what you've been doing with all of your children. You haven't raised a single one of them, and you haven't been working. So let me just tell you, I'm gonna help you with that. And I don't know why you're getting attitude with me. You haven't raised any of your children. None of your children are with you. You have an 18-year-old, 17. Here's the thing. You have an 18-year-old, 17-year-old, 16-year-old, 11-year-old, 10-year-old, 9-year-old, 7-year-old, and none of them are with you. You're not raising them. You haven't been working. You just told me in 5 years. You haven't been financially supporting any of them. Now you have a baby on the way.